About ordinary courts. But now let's turn to the mysterious word of arbitration, and let's surprise ourselves how these competition cases can be important before the arbitration tribunals. Please,
Thank
Gordon.
you very much, Zoltan. Now, first of all, a very small correction. It's actually not quite right that this is the same presentation as I gave in Belgrade. It's actually quite a bit different. The one I gave in Belgrade was a bit too technical, I thought, for the audience at the time, so I thought this time I give a more generic talk on it and just use this opportunity to raise the audience's awareness of the existence of real antitrust arbitrations, but also of the possibilities of using arbitration as a very clever tool in private enforcement, generally speaking, and that could be also interesting for any antitrust regulators which may be represented here or further afield via the video link. Now, the topic has become extraordinarily vast, as a matter of fact, over the past, well, actually I should say that competition arbitration has played a very important role, certainly in Germany for a very long time, and academics have been writing on it since the 1960s. There are PhDs all over the place in Germany on some form of arbitration and competition law, how it all interrelates. Before the Second World War, there were a lot of cartels in Germany, for sure, and arbitration was used to enforce cartels in those times. But in those times also, cartels were viewed as something good and not something bad. So cartel arbitration per se, Kartellschiedsgerichtsbarkeit, as one says in German, was a very well recognized concept and only fell to the prey of market economy after the Second World War, really. Now, in any event, so the history of cartel arbitration per se, which has got to do with competition arbitration, obviously, is a very long one, surprisingly enough. It has gained new momentum since the publication of the modernization regulation, certainly in the EU, because that modernization regulation introduced the idea of private enforcement and what the courts can do, generally speaking, arbitrators can do, subject to one very important caveat, which is once there should be available criminal sanctions for any sort of cartel infringements, whatever it may be, an arbitrator will not be able to mete out criminal sanctions because criminal law per se is not considered to be arbitrable, generally speaking. Now, in any event, the other thing I should be saying, a token of the vastness of this particular subject matter of arbitration is a recent publication which is referred to on my last slide, which I mentioned, though, up front, because any questions you may have or any clarifications you may require after my very brief skeleton presentation, you will, I'm almost sure, definitively find an answer to in this particular work, which is EU and US Antitrust Arbitration, a handbook for practitioners, published about a couple of months back by Kluwer Law International in cooperation with the Chartered Institute of Arbitrators. It's composed of 2 volumes and runs to 2,252 pages. Now, if that's not an indicator of the importance of the topic in the 21st century, then I don't know what is. Anyway, now let's get down to the practical side of things. Now, antitrust arbitration. 2 main categories of arbitration. One category, the first one, I call ordinary antitrust arbitrations under EU, US, and various domestic antitrust laws. These are arbitrations that arise in relation to the implementation of ordinary domestic or international commercial agreements. Second category are commitment arbitrations. These are arbitrations, antitrust arbitrations, that arise from the implementation of commitment decisions, which can be taken by various regulators all over the world, primarily by the European Commission, but also by various other national regulators like the Swiss Competition Authority has got a similar concept like the EU. Now, these commitment arbitrations can arise in relation to conditional merger clearance decisions under Articles 6 and 8 of the EU merger regulation, Corresponding practice we have observed under US consent decrees and in Canadian motor control. Commitment arbitrations also arise in relation to commitment decisions under Articles 7 and 9 of the Modernization Regulation, which entered into force on the 1st of May 2004. The EU Modernization Regulation, I should say more precisely. Corresponding practice we can observe again under Swiss competition law and under individual exemption decisions in terms of former Article 81.3 of the EC Treaty, which is now, of course, 101 in brackets 3 TF EU. This latter practice obviously discontinued with the introduction or the entry into force of the EU Modernization Regulation and the introduction of the self-assessment regime of companies within the internal market. What are the advantages of antitrust arbitration? So, to be clearer, what are the advantages of... Oh, I've got PowerPoints, that's absolutely correct. Zoltan, if you want to play the role of the one who flicks through the PowerPoints as I go snip, that would be very helpful. Excellent. Now, the advantages of antitrust arbitration, of antitrust enforcement through arbitration over enforcement through the courts. First of all, arbitration proceedings are by definition private and confidential. So one can avoid any form of adverse publicity, which I would like to believe is a helpful thing when it comes to antitrust disputes. This stands in contrast, obviously, to the public nature of any court proceedings. Secondly, in an arbitration, the arbitrating parties have a right to choose their own private judge, the arbitrator. They can choose the arbitrator with the qualifications required for the particular dispute. Now, if it's a competition antitrust matter that needs to be adjudicated, I choose a person with relevant experience in antitrust law, relevant experience in the economic application of antitrust laws, and a person with relevant industry-specific expertise, possibly. Because competition disputes can range over a whole range of market sectors, and it may be helpful if one's got a good insight into a particular market sector to be able to get the competition, the law aspects of the case right. That stands in marked contrast to public court judges who very often, especially at the lower level of the court chain, may not have that much experience in competition law at all. Hence, all the training programs we've heard also now having been introduced, I think in Croatia even, right, for judges to get more of an idea under the accession treaty, more of an idea of how to apply competition law and handle it. The only exceptions to this may possibly be jurisdictions like Germany who've got a more specialized judiciary, like Kartellsenate, cartel courts, for example. Third, the award, i.e. the private judgment that is pronounced by an arbitrator, is final and binding and not subject to any appeal on the merits, and enforceable under a wonderful international instrument called the New York Convention all over the world, it would seem. Member states of the convention or convention states account about 140, in excess of 140 nowadays, all the leading industrial nations, including all the European member states. Hooray. So if I have an arbitration award against a conglomerate, I go and enforce it wherever my heart takes me. Maybe even in Croatia. Combine it with a holiday. So, that stands in marked contrast to the more painful enforcement, possibly, of public judgments. What do I do with a public judgment? I need to identify an international convention that allows me to enforce public judgment from court in state A before a court in state B. Is there a bilateral convention, question mark? Is there any multilateral convention ideally in place so that I can take my judgment and enforce it all over the place? If I can rely upon the Brussels regulation within the internal market, fine. But how many of these do we have worldwide?